everybody. Welcome back to my studio, not studio, here in Indiana. Well, we had a lot happen today in day two of the Richard Allen trial. Some interesting developments. So I'm going to go ahead and recap for you guys the various events of the day. Like I did yesterday, I'll go ahead and start by just giving you guys the bottom line, the major takeaways from what transpired in court today, and then I'll go back and fill in some of the details for those of you who like to know all of the ins and outs of what's going on in the courtroom. So bottom line number one, we do have a jury. The jury has been selected. It's final, but we're not entirely sure who it is. Because we have some confusion about the count and about jurors that were removed and replaced. It's a little bit confusing. So I'll fill in a little bit of the details of that for you guys in a little bit. But bottom line there, we have the jury. It's done. It did take well into the day, so we did not get to the motions in limine as they had anticipated yesterday that we would do. So instead, we will be handling those on Thursday. We learned there is a new motion that's been filed. I have not had a chance to look at it yet. But because we have the day off tomorrow, I will have an opportunity to sit down and take a look over it. But we know that it has to do with the composite drawings and that the state has witnesses to call relating to this motion. The witnesses were not going to be available today, so that was part of the reason as well for kicking that down the road to Thursday. They're going to swear the jury, then go ahead and take up the motions, take the evidence, and make whatever decisions the judge is going to make on that particular issue. So like I said, I haven't seen the motion, don't know exactly yet what the request for relief is or what the basis or anything like that. My understanding is it has something to do with an argument that it's hearsay, but I haven't seen the real ins and outs of that argument yet. So next time I come live, I will probably have read that and then can get into that a little bit more, what that's all about. The other real big thing that happened today that I'm sure probably everybody watching this has heard about, we got a new piece of case information that has the potential to be extremely compelling. Because we had a new panel brought in for the jury selection, the parties got to do their mini opening statements again. And so by and large, they were the same as yesterday, with one extremely notable exception, which was during Andrew Baldwin's mini opening, the attorney for Richard Allen. He told us that apparently there was a hair in Abby's hand that was found, and it does not match Richard Allen. So this has the potential to be a really significant piece of information. We'll talk a little bit more about that too in a bit as we go in and break this down. So those are really the main big picture items that happened today. Smaller items. We did get lunch. That was nice. But Judge Gold did snap at everybody out in the gallery again today. So, you know, the more things change, the more they stay the same. I'll just start by, once again, kind of going through chronologically a little bit what the day was like. I got there just slightly later than I was yesterday, probably about 6:45. I was closer to the front of the line this time, but by the time the courthouse opened, there were quite a few more people waiting in line than there had been yesterday. Now, I don't know if all of these people were waiting to try to get into Mr. Allen's trial, or if this just kind of transformed into the line to get through security, to get into the courthouse, period, because we were, waiting for it to open. If all of these people that were in line when the doors were opened were waiting to get into Mr. Allen's trial, then it's pretty clear people were going to be turned away. There wasn't going to be enough room for everybody. We once again had our 25 seats over on the right-hand side of the courtroom, and we had that section. We had that section full. So most of the same faces as well as yesterday. We did have a new addition. Bob Mata showed up today, Defense Diaries. So I got to meet him in person as well, which was super cool. But otherwise, by and large, same media. I didn't see Lana today from Truth and Transparency. I don't think she was able to be there. Mr. Allen today was in light blue shirt once again. Shirt, no tie, no jacket. It looks appropriate for him. Just it suits him. I'm glad that they're dressing him in this manner, not overdoing it. You know, trying to make him look like a mini lawyer. We had a little bit of a discussion in the benches about the exact color of Mr. Allen's shirt. I was going with robin's egg blue, but we also entertained teal and aqua. So those were some of our takes on it. I did this time get a full view of him while he was standing at one point in time, coming in from the back. So I see he's in khaki pants, he's wearing a belt, and he doesn't appear to have a stun belt. You can typically see like at least a little bit of an outline or something like that when the clothing, like if you bend over a little bit or something and the clothing is pressed up against your body. So I did not see any indication of that. It does look like he is pretty much unrestrained in there. That said, there are a number of bailiffs in, very close proximity. So it looks like to the extent they're concerned about security, which, they always claim to be, the reality is hardly anybody ever causes problems like that in the courtroom. Nevertheless, it looks like they would be planning to deal with that if it happened with personnel, not remotely. They would probably go hands-on. So we got our well. Let me back up before I get to the panel, because we had a conversation between the judge and the parties as they were bringing the panel in. So this is where we learned about the issue with emotions and the need for scheduling and so forth. But we also got a little bit of new information. So first off, the judge immediately when she came on the bench, she called the parties, the defense and the prosecutors, up to the bench to discuss the panel. Obviously, we don't hear what is said, but once they had that conversation, the judge announced that 3 of the jurors that had been previously selected yesterday have now been excused. So one juror from the first round, we got no explanation for the reason why that person was being excused. One juror who had disclosed medical issues, this came up during voir dire, and initially it was said that they would be able to accommodate this. It's type 1 diabetes, and they would be able to accommodate the need to eat, drink, potentially, inject insulin at any given point in time. So I don't know what may have changed with that. Maybe not having lunch yesterday wasn't so good from that standpoint. Really don't know. But that juror was excused, and the explanation given was the medical issues. And then the third one the court had received a phone call. This juror had concerns about childcare previously, called in with concerns about childcare. I'm assuming that means wasn't able to get childcare to be able to, show up for the transport on Thursday. So all of those were excused, and that means it brought us back to 11. So we had been at 14, and that means they had started selecting alternates. They had used up all of their strikes for the primary jury, but then moved on into the alternates. The state had apparently used a strike on the alternates. The judge restored that strike, and at this point in time, this point in selection, we were told the state had used 9 of their strikes and the defense had used 7 of them. So I thought that was pretty interesting that the state was, striking more people than the defense. The defense was willing to pass on quite a few people in that first panel. I bring this up because it just speaks to some, I think, very natural concerns that people have had and raised about the speed of this jury selection, and the fact that so many of these jurors were able to be drawn from such a small panel. You see a lot of different jury selections in different venues, different trials and stuff like that. Sometimes it can be extremely extensive. It can take weeks. It can take an extended period of time. It just depends on the process in that courtroom and the issues in the case, the comfort level of the attorneys, whether there's a need for individual examination. So very common, for example, with sex crimes and things like that, people who have experienced that, have family members or friends or things like that that have experienced it. This can be a very touchy thing to potentially consider sitting on a jury for. And so it's often what I'm accustomed to. It's very common to have individual questioning about that type of thing, and people don't want to talk about that sort of thing in open court, I think, pretty understandably. But we haven't seen any private questioning at all in this process. It's all happening out in the open. They have a questionnaire, which again remains obscure. Don't know what the contents of that is exactly. We've gotten some little hints about some of the questions that have been asked, things about like media, opinions, stuff like that. But presumably there's quite a bit in that questionnaire that they've gotten. And so another thing I'm accustomed to is often if the questionnaire raises something that you need to follow up on, again, maybe you do that in closed not closed court, but you excuse the jurors or you handle it individually, do it in chambers, something like that. And with media as well, also, very common, so you don't end up tainting the entire panel. So those things can take up a lot of time. That can cause jury selection to, take a lot longer than it really has in this case. And so I bring up this difference in the strikes just to point out that it does not really appear to me that this is a concern for the defense. It doesn't seem like they are worried about the choices that they have, the opportunities for questioning that they've been given. They seem to be pretty satisfied with it. And so the fact that at least twice, apparently, the state, struck people that the defense was willing to pass on the entire jury, and the state was still dissatisfied with some of the folks who were sitting there. So I do think that speaks a little bit to the process and at least their perception of it as being adequate. And so I feel like that's a little bit validating of kind of my initial impressions of this panel, this first panel. I really liked this panel. I was like, gosh, I wish I could get panels like this when I was picking juries way back in the day. They had so many good things to say. They had good perspectives on the burden of proof, the seriousness of the undertaking, and stuff like that. We learned why, at least the reasoning for the objections that Mr. McClelland was raising to Andrew Baldwin's voir dire on day one. Remember, I told you yesterday, I loved this question. I was so impressed with Mr. Baldwin because he gets up and he asks the jury, is it possible the defendant is innocent? And it's like, that's the question, isn't it? Like, let's just cut right to the chase. That's what we need to know. Is it possible he's innocent? Because if you don't buy that, you don't belong on the jury. He's absolutely entitled to that presumption. He's entitled to that openness of mind. That's the critical part of the process. That's what it means to be impartial. Of course, it's possible that he's innocent. And yet it really did. It just froze. It froze everybody in their tracks. So Mr. McClelland had objected to that. They approached, and afterwards it seemed pretty clear that Mr. Baldwin was not allowed to continue with that line of questioning because he moved on to asking about the confessions, the possibility that confessions can be false, and the extent to which the jurors were going to be concerned about the fact that Mr. Allen had made these incriminating statements. So what we learned was that Mr. McClelland had argued that this was conditioning the jury. And so what they mean by conditioning the jury is basically asking them how they're going to vote, or kind of preparing them to commit to a vote. And so there was a little bit of discussion about this. It was quite a head scratcher to me because I'm still not seeing it. I'm still not seeing it. Uh, Mr. Baldwin kind of asked for clarification. He said, I'm just asking if they already believe he's guilty. I'm trying to ascertain if there's bias. And the judge said that the state had complained about asking if it's beyond a reasonable doubt, would you vote to convict? Well, what's odd is that that's Mr. Baldwin. I went back through my notes. Went back through my notes from day one on this. Mr. Baldwin didn't ask any kind of question like that. But you know who did? You know who did? Mr. McClellan did. Yeah. Are you going to be okay voting if it's proof beyond a reasonable doubt? Weird projection there. But anyway, so she attributed that to what the state was making as their argument about Mr. Baldwin's argument. So Mr. Baldwin says, no, I just asked if he's guilty as he sits here. The judge said, you didn't ask as he sits here, is he guilty? You asked, is he guilty? She's very irritated. Like you can see it in her demeanor. She seems to have a hard time just really maintaining the decorum with Mr. Baldwin. I don't know. I mean, obviously, I don't know what the problem is. I know there's history here. I know that, she's chastised them. It was his office that had the leak of the documents and so forth. But it's really not a great look because it is very obvious. It is very obvious that the tone and the treatment that she gives, even to the other defense lawyers, but certainly to the prosecutors, are very different than the tone that she takes with Mr. Baldwin. So she's very frustrated saying, you asked if he's guilty. Well, that's not asking them how they're going to vote, is it? It's still just not, I'm not following this line of reasoning that was given for why he wasn't allowed to ask that question. But the judge did ultimately say, if you want to ask if they will give him their presumption of innocence, you're allowed to do that. You're just not allowed to, ask them how they're going to vote. That is what conditioning the jury would be. So that was kind of the guideline that was set as a result of that. But I thought that was interesting that we got the insight into the basis for that objection, but I still don't understand exactly what the thought process is about why that applies there, because Mr. Baldwin didn't ask them anything at all about how they would vote. He just asked them about what they thought of his innocence and its possibility. So they had a brief conversation initially about I mentioned yesterday that the judge's preliminary instruction and the definition of beyond a reasonable doubt that she gave, that Mr. McClelland would then follow up on in his voir dire questioning, dealt with basically being firmly convinced. That was kind of the catchphrase that they used. You have to be firmly convinced of the defendant's guilt. And so on the record today, Mr. Baldwin made an objection to the judge's preliminary instruction. He said it doesn't match the pattern because the pattern, says quite a lot more about what the standard is. And so the instruction that she had given was not, it was not thorough. It was not accurate. Mr. McClelland, of course, disagreed with that too. He said, no, the language she's using is in the instructions. The judge said that she had never veered from the pattern instructions, but at Mr. Baldwin's request, she would go ahead and incorporate the language, the full beyond a reasonable doubt instruction into her preliminary. She didn't end up doing that. That didn't happen. She said she would. She didn't. So we ended up basically in the same boat as we were yesterday, where the judge gave a preliminary instruction, and then during the defense voir dire, they would go in and read the entire thing. And it has much more language in it about it being a strict burden, and probably guilty is not enough, and it can't rest on speculation and conjecture, stuff like that. One of the reasons I bring this up is because after that, I was paying attention a lot closer to that preliminary instruction that the judge gave. I'm calling her the judge in part because all day I've been calling her Judge Canoni. I've been calling her Judge Bev. So I'm going to try really hard not to do that here. Judge Gull, the judge, just makes it easier, and hopefully I won't misspeak. But so I paid a little bit closer attention to that instruction today so that I could see exactly what the content was. And there was something about it that I thought was quite interesting. She describes it again, beyond a reasonable doubt is when you are firmly convinced of the defendant's guilt. But then she explains if you are firmly convinced of the defendant's guilt, you may convict him. But if there's a real possibility that he's not guilty, you must give him the benefit of the doubt and vote not guilty. Well, I found this a very interesting contrast between may and must, because one is permissive and one is mandatory. This is something that, one of these little details that lawyers get really super hung up on, when you have to do something versus when you have the option to do something, and the language that courts and legislatures use to reflect what their intent is, which way they intend that to go. And the reason why I find that so fascinating, you may convict if you're firmly convinced of his guilt, that holds open the possibility of nullification, which is not supposed to be a legal thing. Very controversial, very controversial. I mean, everybody understands jurors have the power to nullify, but by definition, nullification is kind of saying we're not applying the law. We're going outside the law. The law says he's guilty of the crime, but we're going to ignore it. So that's intriguing to me. It's something that I want to look into a little bit in the Indiana law, this particular language, where it derives from, why it's phrased in this permissive kind of way. So just really an attention grabber there, because that is quite unusual. Most places, certainly in my state, you can't even breathe, hint at, suggest, raise the fact that jury nullification exists. Like, none of it. It is off the table, and you'll probably get a bar complaint if you do. So just the little cracked door that this instruction seems to leave there is really an attention grabber for me. The panel today, I did not love nearly as much as I liked the one yesterday. It was, first off, considerably less diverse. There was one person on the panel that appeared to be a minority, as opposed to yesterday, probably about five or so. I mean, still not a ton, but more than one. And by and large, just, I mean, there's good things about the panel, bad things about the panel. There just seemed to be, for example, a lot more folks with connections with law enforcement, people who were willing to say things like, yeah, I would consider a law enforcement officer's testimony more credible because they're a law enforcement officer. Oh, that makes me very nervous. I don't like that at all. But there were some good things, though, at the same time. A lot of folks that in the conversations about the burden of proof beyond a reasonable doubt expressed that it really should be higher than that. Like, it should be close to no doubt when you're dealing with something as serious as a murder conviction. And a lot of general agreement on the panel to that kind of proposition. So that does suggest the jurors, they want to be very cautious. They want to be very careful. They want to hold the state to a high burden. We had an interesting point. A lot of people today that had more media exposure, I think, and that had opinions based on that media exposure, specifically fixed opinions about the media exposure. But we did have one particular prospective juror today that they specifically asked him, what is your opinion? You said you have a fixed opinion. What is your opinion? I was shocked that this question was allowed to be asked and that nobody objected to it. But they didn't, and he answered, and his opinion was he's not guilty. So having that said in open court, that's ringing a bell. That's putting it out there that it's people have permission to think that. Like it's I think about the idea of the preference cascade when things are very controversial, or you have an opinion that's not popular, that you're afraid to voice, that you're going to suffer consequences if you voice it, then it's very common to keep that. You just keep it silent. You keep it to yourself. But when you become aware that you're not alone and that other people share that opinion, then it becomes a lot easier to go ahead and say it yourself. So that was what I got thinking about when I heard that person say, I believe, my firm opinion is that he's not guilty, and it's going to be hard to convince me otherwise. I saw that as potentially giving permission to the rest of the jury. To be able to say, yeah, somebody thinks that. If I think that, it's going to be okay that I think that. And just makes it easier potentially to voice that, because it's a hard, believe it or not guilty, even though it's the presumption, it can be a hard position to voice. You don't want to disappoint the family, if they're banking on a conviction. You don't want to risk the guilty guy going free. Most people don't want to risk that, letting him get away with it, because he might do it again. So just having it out there, not because I think Mr. Allen is innocent at this point in time. I do want to be clear about that. I don't think he's innocent. I mean, he's presumed innocent as a matter of law, right? But from a factual standpoint, is he factually innocent? I don't know. We haven't seen the case. We haven't seen the evidence. But it's critical. It's absolutely critical to be open to that possibility if he's going to get a fair trial at all. If you can't hold that open as an option, if you can't bring yourself to think, yeah, maybe I'm going to need to say that, then he's not getting a fair process. He's getting railroaded. So all in all, to me, that was a good indicator that this process is probably going to be fair, because you do have perspectives on both sides. The fixed people, the people with the fixed opinions, are not making it onto the jury. They are getting presumably challenged for cause, and that is very likely being granted. So it's not that like these individual people are going to get on the jury and like skew it one way or another, but just the process of having the different perspectives voiced, it just, I think, helps clarify that, yeah, there is a big picture, two sides to a story, different ways to look at things. And we don't necessarily know how that's going to shake out when all the evidence is in and the trial is all said and done. So let's get to the hair in Abby's hand. The hair in Abby's hand. This was brand new information. This caused, big Twitters through the courtroom. Titters, not Twitters. But it may, it's one of those things that is probably the significance of it could be huge. It could be small. It just depends on other details. This is my read on it anyway. He described it as the hair was found in Abby's hand. So that suggests in her hand, in her hand. Not like lying on top of her hand or something like that, but it's just, we just don't know. The details are going to be very important here. The reason why I say that is because, okay, the significance of a hair lying on her hand, like it fell on her hand, is less, because if it doesn't match Mr. Allen, because, ruling out that it didn't come from a first responder, it didn't come from somebody in the search party, one of the people who was involved in the recovery mission, it's just easier explanation. The question is really what's the provenance of that hair? How did it get there? The story that the hair tells. Because a hair that just, falls to rest on somebody's hand tells a very different story than if the hair is grasped in somebody's hand, or if the hair is entangled on somebody's finger or something like that. It tells a very, very different story. So let's assume that this description was accurate. It's in her hand, not just lying there, but it's grasped somehow, or it's wrapped on her hand, and it doesn't match Mr. Allen. Well, that seems to be of critical significance here, because then where did it come from? Who did it come from? How did it get there? We've heard no theory, no promise of evidence about other culprits, about accomplices, people that Mr. Allen allegedly worked with. From everything that we heard so far from the state in their many openings, both yesterday and today, this is described as a solo act, that it was Mr. Allen that did these things. It was Mr. Allen that had the intentions. It was him that took the actions, and no indication whatsoever of somebody else being involved. But if that's the case, then whose hair is it? And where did it come from? And how did it get into their hands? Remember, they were just on the bridge photographing each other, going on the walk. Are you holding a hair in your hand while you're doing that? It just seems very, very improbable. I read somewhere, I'm trying to remember where it was now. It was one of the early news articles, I think, where they had done a little bit of a just background, information about the girls. And I remember reading, I believe it was Libby that had wanted to be a forensic scientist when she grew up, and Abby wanted to be I think an FBI agent, something like that. There's some poetic justice to that, isn't it? I do. I have to wonder. This is a situation where the child knew the significance of this hair. I mean, if you're interested in forensic science, you would know that. You would know about trace evidence and things like that. So I do think that would be fascinating if this ends up being one of the keys, important keys to the case and solving the question of who committed these murders. So we're told it doesn't match Mr. Allen, but weren't given any other details in terms of like what type of testing was done. Was this nuclear DNA testing? Was this mitochondrial DNA testing? They do have different implications. I mean, not so much with respect to does it match Mr. Allen. That can be ruled in or ruled out fairly definitively, but it does potentially open the door in terms of just how close of a match. When they say it doesn't match, I'm assuming that means he was excluded from it, and so just questions like, is this a high quality DNA sample, like nuclear DNA from the not the shaft of the hair, but the root where it's got some skin and blood cells basically. That can be quite high quality DNA, in which case an exclusion, is very significant. If it's not very high quality DNA, then I mean it's still significant that it's an exclusion, but it just raises questions about potentially the ability to match that to somebody else. Is there other testing that has been done? Have they compared these samples to other suspects, either the state or the defense? Has that been an option? So these are all questions that I'm really intrigued to hear. I'm assuming no. I mean, at least to the extent that they haven't matched anybody else, or they haven't found a close comparison to somebody else, or I'd expect we'd have heard about that today as well. But Yeah, more of those details I think would be very interesting, because then the whole other side of it too, if the state didn't compare it to some of these other suspects, some of the people that they were looking at in the early days, that's going to be something that the defense can exploit. The investigative decisions are pretty much always on the table. And the defense has made it very, very clear in their voir dire that that's going to be a big part of their defense strategy, is critiquing this police investigation. They're going out of their way to make sure jurors are going to be cool with that they're not going to have a problem, or think that, they're being unnecessarily mean or disrespectful. Like you got to respect cops and treat them, with kid gloves or something like that. So just an interesting twist with some implications that we don't really know yet, don't really have the full picture of it. But definitely very interesting information. I'm curious to see what it tells us about the story of this crime. So I'm going to go ahead and pause and real quick just go through some of the comments that have come in, which I really appreciate. Squinting Cat has gifted some memberships. Thank you so much. Thank you on behalf of everybody. Oh, my husband finally became a member. Great. Thanks. Welcome, Jeff. Appreciate your support. Thanks, honey. Chris K, thanks for the coverage here from Lawyer You Know. Oh, wonderful. I've seen Peter over there on Twitter. We've exchanged some chats about this. I'm actually going to be talking to Peter pretty soon for his podcast. So I'm looking forward to that. Really like his work. So welcome and glad to have you here. Trevor Bo Bever is now a YouTube member. Thank you so much and welcome. Jan Price has a super sticker. Thank you for that. Truth and Transparency, Lana, there you are. We missed you today. Thanks for the accuracy and fair reporting. Enjoy the day off tomorrow and chat soon. I am going to enjoy the day off tomorrow. So guys, I'll give you the kind of breakdown of what my plan is with the upcoming schedule. Originally, I was not planning to go back to Fort Wayne on Thursday because all they were going to do was swear the jury. Well, that's changed now. Now we're going to have motions and more evidence, witness testimony, and so forth. So my plan now is I'm going to take tomorrow off. It is the day off. They're not doing anything in court. So I'm going to talk to Anjanette Levy on Law and Crime tomorrow morning about the jury selection and the hair and stuff like that. So looking forward to that. But then I'm going to get caught up on the pleadings, the motion that got filed, dealing with the composite and so forth. And then I'm going to check out a local boxing gym. Looking forward to that. Going to go, shake off some of this sitting. Oh, so much sitting. So much sitting. It's a long drive and you sit all day in court. And guys, I'm not a sitter. I'm a pretty active person. So this is tough. This is not my skill set. So anyway, that's my plan for tomorrow. And then I'll be back in the courtroom on Thursday in Fort Wayne, and plan to just get back on the kind of routine of probably about 7 p.m. is when I'd like to be able to stream. I'm going to have to see once things move over here to Delphi, is that going to work? How is it going to work? And so forth. But that's tentatively what I'm working with. So probably Thursday, that's what you can look forward to is 7 o'clock. I'll come in and then I'll fill you in on what happened with those motions, and also what I've been able to glean from the motion that got filed on the composite images. So that's our schedule. Looking forward to seeing Alana again in the courtroom, and we will indeed touch base again soon. Oh, Farron Foster TV, thoughts of jury breakdown, men versus women, even subs. So like I said, we are in a little bit of an uncertain point. And so here's what happened. Okay, we knew that 3 jurors had gotten had gotten challenged for cause, that were going to, or not challenged for cause, but had gotten excused after being seated and were going to need to be replaced. So we're picking new people. We had 5 new people to pick. We had 5 people picked by about 1 o'clock. But then we broke for lunch and Judge Bev brought the panel back and we picked another. So nobody really knows what that means. We're supposed to have 16. There's 17. Not clear if they lost somebody else somehow in the interim. Not clear if their count was off. I don't know, but nobody raised it. So we don't know. It seems like the logical explanation, the probable explanation is that there was an issue with another juror that we just don't know what it was. It wasn't disclosed to us. So we'll find that out on Thursday when they come in to be sworn, and we'll get our eyes on who actually ends up in that jury box taking the oath. But that being said, given the way that the selections have broken down so far, regardless of which way it goes, it's a woman-heavy jury. There are more women than men. It's just going to be a question of like if a woman had been stricken, it'll change and then replaced. It will change the dynamics a little bit. But we're roughly at 10 women and 6 men. So a woman-heavy jury. I don't really draw too much from that. If you've been on my channel for a while, you've heard me say that my approach to jury selection was never formulaic like that. I did not do the kind of categorization of people. I just don't find it helpful because people will always break the mold and not meet your expectations. They'll be different. There's exceptions and so forth. And so making too many assumptions about how somebody is going to be as a juror because of qualities like their gender, their age, their job, their race, things like that, never seemed prudent to me. So I never did that. My approach to jury selection was always far more intuitive. And it was just based on, can I connect with this person? Do I like this person? Does this person seem to like me? Does this person seem to be open to me? And that's really what I'm trying to explore through the jury selection process is, who are my people? Because if I can get some people that are going to be willing to listen to me, that's what I need. At the end of the day, that's really what I'm trying to accomplish. So I don't know that there's really any significance to there being approximately 10 women and 6 men. But I guess we'll see. I will say that one of the jurors that got excused today, that had been seated and then got excused, was my front runner to be the 4-person. I just had a hunch, just kind of based on personalities that we saw. But that person is now gone. So we'll get eyes on the jury on Thursday. And based on that, I can give you then, final count of who we actually ended up with. And then I've still got my notes that we may be able to go back through and kind of reconstruct, kind of who's who and what sorts of things they expressed, and still ended up on the jury. So that is the jury breakdown. Fair and Foster TV also doesn't matter showing police sketches shown. So this is getting to the motion. Again, my understanding of the motion about the composite sketches is that it's seeking to exclude them as hearsay, which is it's an interesting argument, because an image is an image a statement? Well, it kind of is, intuitively doesn't maybe seem like it, but yes, this image was created based on somebody else's representations or statements out of court, not under oath, about the individual that they saw. And so it's kind of the equivalent of like a translation. You know, you take my words, you translate that into into a drawing, into an art form. And then if the person who's giving that description, if they adopt that, if they, you know, say, yes, this seems like an accurate drawing, a fair representation of the person that I saw, it looks like the person that I saw, then yeah, I think there's a pretty good argument to make. That's a substitute for their statement. So does that make it in and of itself automatically inadmissible? Well, no, it could still potentially come in under a hearsay exception if there is one. And so that can depend on who's offering it, who wants it to come in, right? Because if it's the opponent, then sometimes you can bring that in as a statement against interest. If it's person gets on the stand and they're testifying, that the person who made the description, and they're testifying about what they saw, and it's not consistent with the drawing, then it's impeachable. Then you can bring the drawing in to impeach them and say, well, you know, what you just described is not consistent, you know, with what was produced here based on your description. So even if it is hearsay, it's not necessarily a flat out bar under any and all circumstances. But like I said, I am going to need to get into the details of that motion and exactly what they're asking for and what their basis for it is. Danielle Cole, thank you for covering. Well, thank you for being here and for supporting my work and my channel. I really appreciate it. Farron Foster TV, does it matter he confessed at all to the murders? Well, it definitely matters. I mean, it definitely matters because that's a huge part of the state's case. They've made it very clear. Mr. McClelland repeated his many opening today. This case is about three things: bridge guy, a bullet, and two murdered girls. Two murdered girls. The bullet is not a strong piece of evidence. There's my understanding, there's issues with the chain of custody in terms of when it was discovered. It wasn't discovered at the same time that the girls were recovered. It was discovered only after the scene had no longer been secured. So again, the provenance of it, a little bit questionable. And it also just a little sketch, right? Like if you're recovering the girls' bodies, you think you would find it then, right? If it's supposed to be right there lying between them, why wouldn't you find it then? It wasn't nighttime. I don't know what the explanation for that is. So the bullet, the only reason the bullet, I think, gets strengthened is because they can bolster it with those statements that they got from Mr. Allen. It seems fairly evident at this point that that's what the state is relying on to develop their theory of how these murders took place, what he did. He pointed the gun, he wanted to have his way with them. He ordered them down the hill, ordered them to take off their clothes, ordered them to go across the river. That's, I mean, my suspicion, because I don't know how we would have any other evidence of that, right? Nobody saw it. Nobody saw it. There's nothing objective that would really tell you that happened. So it seems pretty likely that Mr. Allen said these things in the course of these various incriminating statements that he made. And that's now what the state is relying on to say that, well, this is how the crime happened. Of course, the problem, as the defense has pointed out, is that he said a whole bunch of other things too, and they weren't right, they weren't correct, they weren't accurate, they didn't happen. He didn't shoot the girls in the back. that didn't happen. So him confessing to it is a little bit of a problem. The state seems to be cherry picking. The stuff that they can work with that helps them, they're going to rely on that. The stuff that doesn't help them, they're not going to acknowledge it. Or perhaps they'll acknowledge it, but they'll have some explanation for it. I don't know what that's going to be, right? Well, he tried to lead you astray. Well, but he's talking to you. You're saying like pick a theory. Is he confessing to get it off his chest to his wife and his mother, telling the truth? Once he opened his mouth, how is he gonna lead him astray? It's a strange theory to me. Partially truthful, partially untruthful. What the motivation for that would be? I have my suspicions. I mean, I certainly have my suspicions because I understand how these false confessions go. When the motive is, I want this to be done and I want to give the police what they want so that they will leave me alone. You tell them what they want to hear. And there's a process where they feed you those details. And then you learn how to puppet those. So that's my suspicion, is that this was a fishing expedition by Mr. Allen to figure out, what do the police want to hear? I will tell them. I will tell them different things. Nope, that's not it. Okay, then I will tell them another thing. Oh, that's not it. Okay, well, I will tell them this thing. Oh, yay, that worked. They liked that. It's just kind of textbook, how that goes. So, ultimately, does it matter? It's going to be up to the jury how much it matters. I mean, but it's clearly a significant piece of evidence. It's something that the defense has to deal with. They have to address. At the same time, the state is going to have to explain the problems with these confessions and why we should believe them when the totality of what he expressed is not accurate. Didn't accurately describe what happened. Sean H, woohoo! I agree. Woohoo! We had lunch today. We actually got 2 breaks today. We got about 10 o'clock break at noon, and then about 1:15 or so we got lunch. We got 45-minute lunch break. So we did get out of that courtroom. I got to go to my car and bolt some of my little car snacks that I had. So not so low on the blood sugar today, which is great. Kat Not Williams gifted 20 memberships. Thank you so much, Kat. Thank you to everybody on behalf of everybody who got one of those memberships and is now green over there in the chat. Sharon Laberthon. Here because of Rob from Law and Lumber. Thank you so much for covering this. Well, thank you and welcome. Appreciate having you here. Love Rob. Been on his channel. Hope to be able to touch base with him again soon. Kraken Studio, the real booty. Where in Washington are you and do you still practice? So I'm located down in southeastern Washington, in Tri-Cities is the area. This is my hometown. It's where I grew up. I left for a while and then I went back home. So it's, everybody, I'm sure, has a little bit of ambivalence about their hometown, for that reason. I do love it. I really do. But it's got, like everywhere, it's got issues. It's got things that I would improve upon in a perfect world. But do I still practice? I do still practice, not so nearly as active as I used to be. My early practice, was extremely busy, as lawyers often tend to be. Just burn the candle at both ends, trying to get everything done. You have to kind of learn how to say no. You have to learn that if you turn down a client, the world is not going to end. There will be other clients that will come in the door. You can be selective about the things that you choose to work on. I've always had a background in public defense. It was my very, very first practicing law job out of law school was with the Yakima County Public Defender. I could tell war stories about that for a long time. Very different community than where I ultimately ended up doing most of my legal practice. And so after I left there and was a private practitioner, I did a lot of different things, civil work as well as criminal work. But I pretty much stayed a contract public defender, at least part-time, in different jurisdictions for most of my legal career. So I did trial work for in the ballpark of probably about 10 years, maybe a little bit more. And then similarly, starting about maybe 2010, 2011, somewhere in there, I started doing contract appellate work, indigent defense, on the appeal level. And so basically, somebody who had a public defender at trial, lost their trial, got convicted, had appeal issues, I would be appointed to represent them on appeal. And that's currently what I still do. Yes, still work, still have cases. I got to go argue a case in December. It was supposed to be argued this month, had to move to continue it because I'm going to be here. But I am tapering down a bit now. It's, I'm lucky to be at a point in my life where I don't have to work as hard as I used to. I don't have kids. I'll tell you right off the bat, it makes a very big difference. So that's a little bit about my story, my background, and what I do with the law. Farron Foster, reports showed one worked with kids, excused. Yikes. One worked with kids. Let me see if I can find that. Yeah, I'm not sure. The one that was excused for medical issues was a professor, a seminary professor. So not kids, but certainly young adults. The one who had the issues with childcare, I just don't recall. And same with the one from the first round. They didn't give us a reason. So I don't know. I can't confirm or deny that. Just don't know. Haywood Jablome, you said that you were concerned about diversity. This is something that it has been studied. There is some scholarship on this that diverse juries are better. They will be more careful. They will talk about more of the issues. They're less likely to just walk in and reach a snap decision. They will look at things from different angles better. And this is, regardless of what the, opinions are that people are bringing into the jury room, like, personalities and political views and things like that. Like it's not because, people necessarily have different viewpoints because they have different racial backgrounds or something like that. It's just something about the environment being more diverse that encourages a more robust conversation. So I am in favor of diverse juries. I think that's good. I think it's generally positive. Now, at the expense of everything else, of course not. If you can't get an unbiased jury, that's diverse. You gotta start with the basics. But yeah, everything else being equal, I do think that is an important quality to try to get out of a jury if possible. Cam, what's Alan's responses to seeing all that jury selections? Does he interact indirectly with them? Thank you for your live streams. So Mr. Allen interacts mostly with his team. I don't see him really reacting to the jurors, trying to make eye contact or anything like that. This morning, I did have a little bit more of the impression. I don't know if he's still medicated. Okay, I know that at one point in time when he was in prison, he was put on Haldol. I know Haldol. Had a lot of clients on Haldol. It's a very strong antipsychotic. It can be like a tranquilizer. Like it can really knock people for a loop. You can deal with some of that a little bit with dosage, but it really can knock people out. So I don't know if he is still receiving any Haldol. He certainly wasn't, like doped to the gills or anything like that, but he did in the morning. I just got the impression that he seemed maybe a little slow. He'd kind of space out. It seemed like looking at the ceiling, looking at the wall. It's so hard to judge because he obviously spent so long in solitary confinement. He's back in jail now, so it's different. But the total sensory deprivation, that you have in that type of setting, and then going into this courtroom, which, as I mentioned yesterday, I would not call it tasteful. This is my opinion. I'm not an architectural expert, and it doesn't matter what I think. I don't like it. Just saying. But there's like a billion colors around, and so much of this ornamentation. I mean, so many things to look at: beadwork, scroll work, painted, the pineapples, all types of little filigree carvings, coffered ceilings, all of these different, paint colors and stuff. I mean, it's just a lot. It is a lot to look at. So I don't know if he's just taking it all in. Like, there's so much to look at. He's just taking it all in. I don't know if he is, potentially still slightly medicated, and that's, making it maybe easier for him to zone out a little bit or something like that. So I did see that this morning. But as the day went on, it did seem to improve. He was certainly still talking, alert, able to communicate with his attorney, primarily again with Mr. Baldwin. He seems to be talking at a normal speed. He's not like slow and slurring or anything like that. That would also, be consistent with being heavily medicated. So he's not, like I said, real interactive. I haven't seen any indication of him trying to interact with the jury really at all. He's interacting mostly with his team to the extent that he's interacting with anybody in the courtroom. He will look around from time to time. Look out into the gallery. He'll check us out, and just kind of take us all in. But he's very poker faced. He doesn't seem to really express anything when he's doing that. So have not seen any kind of attempt to interact with the jury like that. Precocent. Low on the hierarchy of importance. People would like to get updates on Rozzy's tie sock choice for the day. I didn't see his socks, but today his tie was like a pinkish purple. It was eye catching. It was, I rather liked it. I just got done talking about the lack of taste in the courtroom, and here I am complimenting a like almost fuchsia tie. But it worked. It worked. It came across as a elegant, kind of choice given the total ensemble. So didn't see his socks though. I'll have to start taking a look. I'll file that away. Noted. People want to know about Mr. Rozzy's socks. Farron Foster TV, what is the defense's best defense right now? I think the defense's best defense right now, I think they have, the impression that I'm getting is that they're pretty solid on being able to challenge the confessions. Like, the jurors generally are receptive to that. They've expressed the understanding that type of thing can happen, that it's real, and maybe we don't understand it. Maybe it's hard to relate to that situation because we've never been in it. So you can't really put yourself in that person's shoes. It's just too hard to imagine. But nevertheless, they understand Sure, everybody's got a breaking point and they understand why. You know, this idea that, yeah, you just want it to be done and you'll tell them anything that they want to hear. So I don't think the defense is going to have too hard of a time challenging the confessions. I do think they have a harder road to harder hill to climb with challenging the bullet, the markings on the bullet. And I say this as somebody who went on rants yesterday about what a bunch of junk science this is. Like, it's something I've litigated. It is a hot button issue for me. If you want to get me mad, talk about these types of ballistics comparisons. Particularly this one, because an unspent bullet, it's some of the lowest of the low quality of evidence. It hasn't passed through the rifle or passed through the barrel of the gun. The barrel is the part of the gun that is most likely to be unique relative to the, guns are mass manufactured now. You don't, it's machine manufactured. You don't get like a handcrafted gun routinely. Overwhelming majority are not that. So for most guns, mass manufactured, coming off of a machine, there's not really a lot of logical reason to think, well, why would gun A, like the first gun that came out of this batch manufactured, why would it produce significantly different marks than the 1,000th gun in this run? It's, you're not going to have that much effect on the manufacturing equipment that like it's gonna start to warp, or it's gonna start to change, or it's gonna pick up dings or things that get transferred into the gun materials. It will, I would think, over a long enough period of time. But so it just raises questions about how unique are these markings going to be anyway. Now, barrels of guns are still commonly rifled individually by hand. So they do have more of a tendency to have more unique traits. But the markings on this bullet are not from that. They're just from the magazine and the ejecting mechanisms. So how many guns would share that? Well, number one, we don't know, because it's never been validated. Nobody's ever done a study to say, well, how different are these? And how can we objectively quantify that in a way that allows us to distinguish between, these marks are so similar that it means that they came from the same gun, versus these marks are pretty similar, but not so similar, that they came from the same source. We don't have that information to be able to make those kinds of claims. So the science is absolute junk, and it really gets under my skin when they make these claims. It would be one thing if they were making the claim that is supportable, which is that it's consistent. The marks on these bullets are consistent with coming from these guns, because it is. It's a rule in. You're saying we can rule in this gun as a possible source of this bullet, but we're not ruling out every single other gun in the entire world. We're not saying the only gun that this could have come from would have been this bullet. So that's the distinction between the claim that really can be supported by this type of evidence and the claim that does not. It does not have the scientific foundation to be able to make that. So having said all that, I think it's a hard sell to the jury. I mentioned yesterday one of the things that Mr. McClelland has done in his voir dire that I think might be a little bit of an own goal is he's asking the jurors what kind of evidence do they want to see, and it's invited them to volunteer all of the things that they're not going to get: the location records, the DNA, the eyewitnesses, the phone calls, video, so on and so forth. They're not going to get any of that, but the weapon, everybody wants to see the weapon. And This is what's going to pass for that. Right. So number one, the jury is hungry for it. They want this type of evidence. They're expecting it. And I think that just maybe has the potential to skew the perspective a little bit as far as the significance of this particular item. But just that aside, it's a very technical challenge. The state is going to have an expert who's going to come in and she's going to say, my profession, my job is to look at markings like these and compare them to a firearm. She go through, get a fresh bullet, do the same type of action, whatever it was, with the firearm. On a fresh bullet, compare that fresh bullet with the one that was found at the scene and see if they're the same, see if they match. That's my job. I've done it thousands of times. I've never gotten it wrong. It's pretty compelling. It's pretty compelling. She's going to get up there and she's going to say, this is Melissa Oberg, the comparison. The toolmark examiner, she's going to get up there and she's going to say, yeah, I have standards that I have to follow. I'm a member of a professional organization, hold a credential that certifies me as having competency in being able to do this. I have to go through regular education. I have to go through performance testing. I have to show that in a test, in a black box test type of situation where I don't know what the correct answer is, that I can accurately distinguish which bullet came from which gun and which ones match and which ones don't. I have to pass this proficiency testing on a regular basis, and I've always done that. The jury's going to hear all this stuff. And Mr. McMillan has been planting these seeds in his voir dire. Not just you want to see the weapon, but also what sorts of things will give an expert credibility. How do you evaluate an expert's credibility? And people are like, oh, well, I'm going to look at their credentials. I'm going to look at their experience. If they've got highly specialized experience and knowledge, yeah, I'm going to be more likely to find that person highly credible. Oof. So it's going to land, that testimony is going to land. And the defense, they can probably poke at that a little bit, but by and large, their rebuttal of that claim is going to have to wait until their own case when they can put on their own expert. And so they plan to put on this metallurgist, PhD scientist, who looks at the qualities of these materials and how these types of marks would be produced, and essentially explain to the jury why the theory doesn't work, why this tool mark examination, it's not statistically validated, it's a subjective process. The standard, okay, when they're looking at those two bullets, the fresh one and the one that they found on the ground, and looking at, are the markings the same? You might have heard, like with, for example, fingerprint examination, you need to find so many points of similarity, 7 points, 13 points, 20 points. Just, depends on how specific you're getting. And the standards have changed over time as well. So you might think there'd be something like that similar, some objective reference that you could have with the bullet. No, with tool marks, it's sufficient agreement. If there's sufficient agreement, then the examiner can say that it's a match. What's sufficient? Yeah, that's the $1 million question. Because it's up to the examiner to decide if it's sufficient or not. So that's why this is a subjective standard. It's not something that any person could go and take the measurements or look at the different points of comparison and verify that and validate it. It's not really verifiable. People can have different opinions about it. So it's a little bit technical when you're getting into these just the foundations of scientific reasoning and why some things work and why some things, some claims work and some claims don't work. And I think that might be a tough sell for the jury. You know, that could be hard. It sounds like, you know, potentially there's a risk. Are we going to be, you know, does this sound like a technicality, like we're trying to weasel out or something like that? It's always a little bit of a risk. And in a trial where you're dealing with people, it's just one of the unfortunate realities too, is that personalities matter. We don't know what personalities we're dealing with. If the jury really likes the ballistics examiner, or the tool mark examiner, the state's tool mark examiner, maybe they don't like the defense's expert, or maybe they can't relate to the defense's expert. Maybe the defense's expert is kind of an egghead, you know, and isn't able to explain things in a real down to earth way. It's hard for them to follow it, hard for them to relate. These are just all things that can have a big impact, and it doesn't change the bottom line that this really isn't good science, but how do you communicate that to the jury, and how do you persuade them this is not sufficiently reliable for you to hang your hat on it? So that's where I think we're at right now. This hair could potentially be a game changer. Like I said, the hair could potentially be a game changer, just because it could potentially really change the story of what happened and create a big hole here that the state has to explain. If this is unknown male hair, I mean, it could be unknown female hair too. I guess that just seems maybe less significant to me, because it could be a friend. It could be like, you know, I guess it would matter too if it was unknown female hair. Either way, if it's unknown source, it's in the hand, really changes the story. How and when did it get there, and why, and from who? And the state doesn't seem to have the ability to explain that. So that has the potential to be a very strong part of the defense, but we're going to have to wait and see. So far, the defense is really emphasizing the confession and the falsity of the confession. It does seem to be a strong point for them, and it does seem to be one that the jury is receptive to. Farron Foster, glad you got in court asking questions from my reporter. Well, happy to help. I'm glad I've been able to get into, hopefully the pattern sticks. I am certainly, you know, expecting things to change in Delphi, because I don't think we're going to have 25 seats for public and media. So we will see how that goes. Farron Foster, one of the juror members is allegedly a preschool teacher. There have been several folks on the jury that have education background. I'm trying to remember if it was the last one selected, the last alternate, or... Oh no, I know. I think I know. There was a juror from the Department of Education who was, I believe, one of the main jurors, not an alternate. She was in one of the groups today. I think the first group. I was kind of surprised the defense let her on. I probably wouldn't have if it was me. Again, because my thought process tends to be intuitive and not there's no recipe, you know, for what makes a good juror. But I really didn't get good vibes from this juror. I didn't get good vibes. But yeah, that was certainly somebody who has the background in education. Yeah. Dolly Talk. So you haven't seen him make eye contact with you and smile? No, and I didn't wink at him like I did Ioan Griffith. No. It's... Like I said, he's looked out at the audience, but he doesn't seem to be looking for eye contact or necessarily wanting eye contact. Definitely haven't seen him smiling or having that kind of reaction to anybody other than his attorney. Kraken Studio, the real booty. Regardless of the gun? Where is a sharp device that they actually died from? Or are we speculating sharp versus gun cause of death? By the way, I'm in Ellensburg. Oh, I know Ellensburg well, drove through it many times. My good friend Heidi, who you would know from my fish if I were in my real studio. Heidi is the maker of my fish. She went to Central Washington University over there in Ellensburg, so she knows it well too. So no, the cause of death, my understanding, we know sharp object. We know slicing and yeah, a bloody. There was no shooting. Nobody was shot. So that is the $1,000,000 question, right? Where is that? Where is that particular weapon? Don't know. Don't know. As far as we know, it wasn't recovered. It's not in evidence. I think part of the problem is obviously the amount of time that elapsed between the killings and Mr. Allen being arrested. The state is, simply going to argue, well, he had plenty of opportunity to get rid of it. Of course, he did the gun as well, and he didn't. But maybe they would take the position that, well, he didn't use the gun, so maybe he didn't worry about having the gun, traced back, whereas the knife, maybe they'd be able to match the blade to the wounds, or maybe it would, have blood that he wouldn't be able to remove or something like that. So a more obvious thing to get rid of. I think that's the obvious argument for the state to make. Where's the knife? Well, he got rid of it somewhere at some point. He ditched it. They never found it. From the defense, where's the knife? Well, it's with the killer. The person who really did it. Yeah. So those are the arguments that I think we're going to hear about that. Farron Foster TV. Go on about the preschool teacher. No objection. No. No, defense let that person on. So not the call I would have made, but I'm not the one doing the questioning. I'm not the one up there doing the evaluation. They certainly have their own strategy and their own thought process. So they got a different read than I did, and we'll just see how that plays out. But yeah, my goal is, because I do have all of these extensive notes, but like I said, kind of tracking who is who, and then tracing that back to the types of answers that they gave in jury selection and stuff like that. It's going to take me a little bit of time to just go through everything and organize it. So once I get eyes on them on Thursday and kind of know for sure who we're dealing with, I think that will help me be able to go back through and reconstruct some of that stuff. We didn't necessarily hear a lot about people's backgrounds. It was one of those things that it was probably in the questionnaire, but it didn't come up much in questioning unless one of the parties specifically asked, and most of the time they didn't. So there were only a few people that we heard their profession: the seminary professor, the Department of Education. There was a pilot today that got excused, was going to be flying to Saudi Arabia in 5 days, and I imagine quite a process getting a visa to Saudi Arabia, so that was going to be an issue. We had a heavy equipment operator. Mostly when we hear about it, it's because somebody is claiming a hardship, financial hardship, explaining what they do and why they can't be away from that job, why they can't be replaced. There was a pianist, just all kinds of different interesting professions, but not a situation where we got everybody, on record with what they do. So the few that we did get did kind of tend to stand out a little bit. So yeah, that's where we're at with the jury. So I guess the last thing that I would say about kind of what happened today, I mean, I did say I didn't have that same immediate love of the panel today that I had yesterday. Really liked the panel yesterday. Had a very positive impression. Today was different. But it's hard to tell how much of that is just, the vibes again that we get from them, the answers that they gave to these certain questions, and some of it too. Just I feel like none of the lawyers did as well today. None of them. I mean, Mr. McClellan didn't do as well. He I would say today was probably the most effective of all of them in terms of being able to build those connections. There was one juror I remember. I don't think we know her profession, but she made it on. She was another one that was borderline. I probably would have struck if I were defense counsel. And the reason why is because she certainly gave a lot of good answers to questions like, the importance of the beyond a reasonable doubt, and you need to be very sure, and things along those lines. But she was just very visibly like infatuated with Mr. McClelland. Like as soon as he got up and started talking, she just lit up. Her eyes followed him. She smiled. She laughed at his jokes. She's nodding at everything he said. He had her eaten out of his hand. If I'm the defense lawyer, I don't care if you say all the right stuff. I don't want you liking my opponent. That's a problem. You shouldn't like him. You need to like me. uh, so he was successful at that. McClelland is he's very skilled at that, at being able to have that chit chatty kind of relationship, and so. Unless you're maybe a little more of a disagreeable person, like probably I am, where you don't necessarily like that or respond to that, or maybe are a little bit suspicious of that. Like I described him yesterday as maybe a little bit used car salesman-y. That might have been uncharitable because that comes across as sleazy. But he does have that ability to get people to like him. That does seem pretty clear. Agreeing with people, sharing stories with people, having that kind of easy rapport that he's able to build. So he was able to still pull some of that off today, even if he didn't necessarily, land anything really strong with his questions. He didn't really prevent the defense from being able to rehabilitate some of what he did. He had with one of the panels a good moment with the firmly convinced, like he had just really talked them down off of what a high standard beyond a reasonable doubt needed to be, and had them kind of willing to entertain, yeah, if I'm really pretty sure that's probably good, and so then the burden is on the defense to then get back up and be like, hey, the standard says probably guilty isn't enough. There was one of the jurors on this panel that when the defense raised that and asked him, what do you think of it? He's like, that's kind of mind blowing. Probably guilty isn't enough is kind of mind blowing. So they had their work cut out for them, I think, and just didn't really hit the home run today. They had a very good moment. I mentioned yesterday when Mr. Baldwin just completely deflated the example of that Mr. McClelland was using. Do you believe I'm a lawyer? And he's trying to explain that, well, I'm just, I'm not saying this is the same kind of decision as deciding if Mr. Allen is guilty or not. I'm just trying to show you how you can be firmly convinced about something without necessarily having a lot of evidence and just relying on your common sense. Because here I am in the courtroom, and the judges obviously let me be here, and I got elected to a position that requires you to be a lawyer, so you can use your common sense and Sure, it's possible that I faked my bar card and I fabricated my certificate, my diploma from law school, and all of this has just been a big sham, but that wouldn't be reasonable. So he made a lot of headway on kind of minimizing what a reasonable doubt is. Uh, And the defense didn't have that moment today of being able to really blow that up. They told the same story again this time. Ms. Auger told the story. It just was not. It just wasn't effective. She had a hard day again today. She struggled. I had some points where in my notes, I wrote down some of her questions, and in the margins, I just wrote ugh because I hated the question. It just wasn't a good question. I'll give you some of the examples. So when she addressed the analogy and she told the story. There was a lawyer in our jurisdiction. He was hired by a law firm. He was practicing in court in front of the judges. Turns out he wasn't actually a lawyer. And here's what she followed that up with. Sometimes we have to look a little deeper. Is that a concept anyone has a problem with? Do you think anybody had a problem with that concept? No, they had nothing to say about that at all. It's just not a good question. It doesn't invite any kind of a response. It's too obvious that everybody is on the same page with that. And so with something like that, I think where you have to go, you have to just explore the details a little bit. You can't go straight to where you want to be with the juror. You have to let them get there themselves. You have to lead them there so that they will reach the conclusion, oh, maybe we need to look a little deeper. And so you would maybe share this example, and maybe you would ask, can you think of ways that maybe you would have come to suspect something was wrong? How do you think they found out? What was the giveaway? How might you even have that question come about in the first place? Explore that and what kind of inquiry you'd need to make and why you would make that type of inquiry, because Mr. McClelland has, already sold the jury on it's pretty much not reasonable to even ask. But in this situation, it clearly was. And so why are they different? I think exploring that would have been potentially more helpful than that question. Another one, can you imagine a situation where you are wrongfully accused, but you don't want to stand up and defend yourself when they're talking about self-incrimination? No, they're not going to be able to imagine that. They're not going to be able to imagine that. You've got to feed them something. You've got to feed them an example. You've got to put them in the shoes of Mr. Allen and put them on the stand and experience what he would be going through so that they can begin to relate to that. Have you ever done something that you deeply regret? And you probably have a lot of complicated feelings about that. And that's something you might be a little bit sensitive about. You probably aren't going to be comfortable talking about that openly. Do you want to share all of your mistakes with the whole world? How do you explain a mistake without it sounding like you're making an excuse? How do you take accountability for what you did, but still distance yourself from it, still disclaim it as untrue? I just think it would have been more productive to try to flesh out that experience instead of trying to get them to gin it up in a vacuum. You have to feed it to them a little bit. Has anyone ever been under so much psychiatric stress that you can't perform your best? Wasn't great, psychiatric stress. Is that a technical, it was unwieldy. Mr. Rozzi today seemed a little bit off too. He used a lot more just legalistic type of language. So for example, when he was asking them to consider what can you do, how are you going to take it if Mr. Allen doesn't testify? Are you going to hold that against him? So on and so forth. He kept saying Mr. Allen's non-testimony. His non-testimony. It's just, that's awkward. It's just awkward. It sounds lawyerly, I just feel like that type of thing is better when you say, if Mr. Allen doesn't testify. Mr. Allen's non-testimony. It was awkward. Another thing that Mr. Rozzi did that struck me as maybe being he was a little bit off his game. He kept saying, I talked about this yesterday, or we talked about this yesterday, or this came up yesterday. I said this yesterday. This panel wasn't here yesterday. They don't know what happened yesterday. And frankly, they don't care what happened yesterday. It doesn't matter to them. So, I mean, it didn't hurt anything. It's not like that's detrimental. It just seemed off. Like, they weren't here yesterday. Why are you bringing that up? They can't relate to that. So you're already kind of separating yourself from them by focusing on yesterday that they weren't a part of. So just little things, not major things, but it did. It just overall contributed to the vibe that today didn't go quite as well for the defense as the first day did. So fortunately, we weren't picking that many people, picking a juror, picking some alternates. That said, at the rate that people are dropping, already, people that have been seated, I am concerned. I really am concerned that we're gonna get through with enough people. Four alternates is a lot, but a month is a long trial. So we'll just have to see how that fleshes out. GSU PM, why is no fam present for victims besides grandfather? I don't know. There were, the way I explained yesterday, the way the courtroom is configured, the jury panel is sitting over on the left-hand side. The public and the media are over on the right-hand side. And then in the back of the courtroom behind all of us, there are some benches. I feel sorry for them because we have nice cushioned chairs. These benches are the hardwood pew style seating. Not very comfortable looking, but anyway, they're very far behind us. They're not in our line of sight. And so, I'm not trying to be a looky-loo. I'm not trying to eyeball them in their moment of grief and stuff like that. I'm trying to give them some dignity and privacy and stuff. So not overly focused on what is happening back there in those benches. There are a number of people there, but I don't necessarily know who they are. They're not full. I'm certainly expecting more once we get to trial. There's only a couple of faces that I think I would recognize at this point in time, because I haven't, like I said, I haven't been to these hearings before. I would recognize Abby's grandmother. I'm pretty sure I would recognize her. I didn't see her, but like I said, I wasn't looking. So I really don't know, other than just maybe this doesn't matter to them. This isn't a part of the process that they feel a need to witness. This isn't part of getting answers. This is just This is just choosing the deciders. And yeah, I don't know. I don't have an explanation for why they aren't there. Precocent, criminality et al. Asking about Coke dealer hair, but also AB. But also, did you know McClellan's license plate, the boss? I did not know that. Oh, he's a character, this guy. Already getting that impression. Rochelle D. Gull's moodiness has affected everyone in the court. I mean, I believe it. I definitely get a sense of walking on eggshells. So I'll give you an example. When I mentioned she really snapped at the media at the end of the day today, and so what had happened? The jury, once again, I think the jury had gotten excused, and the parties were up at the bench. They were talking about stuff. It was in a transitional stage, like court is over-ish, but we're still on the record. She hasn't left the bench. There's still kinds of things happening, but we're not in a formal hearing type of setting. It looks very casual. The attorneys are milling about, not seated at attention at their tables. So a gentleman from the media in the front row got up and kind of turned and was getting ready to leave. And Judge Gull snapped at this man. I want to get the exact words because I wrote them down. That was from yesterday. Let me see here. We're still at work. Sit down, please. Very, very snappy. Well, this guy is kind of diagonally behind Mr. Rozzi. And Mr. Rozzi is kind of sitting half out of his chair too. And Mr. Rozzi freezes and like turns and looks at her and turns and like he thinks she's talking to him. And because, I guess he's sitting there half upright and she's snapping in this direction, and apparently it's not entirely out of the realm of believability that she would be talking to him. He thought that was at least possible enough that he reacted to it. So yeah, I think this is legit. It has had an effect. People are maybe behaving a little bit differently just in anticipation of what they think she's going to do or not do. I mentioned yesterday my personal perspective was that Mr. Baldwin was the strongest on the defense team at the voir dire. He had the strongest performance. But the attorney who actually did more of the rounds than anybody else for the defense was Mr. Rozzi. And I do wonder, is that decision in part because of that hostility towards Mr. Baldwin that Judge Gull is not hiding? I don't think she's even trying to, but if she is, she's not doing a good job. It is crystal clear. Is that inviting Mr. McClelland to make these objections, because he knows, she's got all this antipathy towards Mr. Baldwin. She hates him. She's going to give me whatever I want. He didn't object to Ms. Auger, he didn't object to Mr. Rozzi. So I don't know. Of course, these are possible, but there's no way to know. I'm not a mind reader. But I think it is a legitimate question. Is it affecting people's behavior like that? The Iceman 101418. Andrea, so thankful for your coverage on this. Been contemplating the prison part of this. How is it constitutional? Being put in prison isolation without a trial seems like a clear Fifth Amendment violation. Their excuse is that it's not punishment, right? Prison? No, it's not punishment. It's for his own safety. It's for his own good. It's for his own good. That's the rationale. And for better or for worse, judges will almost never second guess the security rationales that they get from law enforcement. If law enforcement tells them we need to do this for security reasons, 99.9% of judges, 99.9% of the time are going to say, okay, well, then that's what we're doing. They don't want the responsibility for the courtroom being unsafe. They don't want the responsibility for second guessing those security decisions and then they're wrong and then something happens to Mr. Allen. They don't want that on them. So they just go ahead and shove that responsibility off onto law enforcement. So if law enforcement says he's got to be in prison, it's the only way he's going to be safe. We just can't keep him safe here. It's for his own good. Yeah, I think most judges, they're going to say, okay, got to do what we got to do. I had a case where a guy was housed in a prison, pretrial. This was a case on appeal, so I wasn't working with him at the time. But boy, whole complicated situation. This was during COVID. And so the guy was over in Clarkston, Washington, which is way, way over on the east side, almost in Idaho, over by the border with the Snake River. He was in the local jail. According to the state, there was some sort of incident that created security concerns in the jail that the defendant was involved with. Never really got a lot of details about what that was or how it happened, what he did, because the court's so eager and willing to go along with security representations by other people. So it didn't require an extensive explanation. But anyway, for whatever security reasons, then the jail could no longer keep him there. So they transferred him to Walla Walla Penitentiary, Walla Walla Prison. It's about 150 miles away from Clarkston. So this ended up being part of the issue on appeal, was that he was too far away from his attorney to be able to communicate with his attorney. As I read through the court file in this case, in Mr. Allen's case, and particularly those affidavits about the prison visits when they were litigating the safekeeping order multiple times, describing what it's like to go through security, how the prison guards sit there and eyeball you the entire time and don't allow you any confidentiality, and you can't bring in anything and you can't pass materials back and forth. This is spot on. Okay, I've lived this. That happens absolutely all the time. You can typically make phone calls to the prisons fairly easily now. They have ways to, program the attorney lines so that they don't get recorded, and at least we're told. We haven't found out yet. It seems to always happen little more often than it should. Attorney phone calls are getting listened to, intercepted. But at least ostensibly they're able to do that. So you can make phone contact relatively easily, but you can't review discovery over the phone. And I ran into this problem as well when I was preparing for a murder trial. And my client was already in prison. He was in prison on a different charge, and he had, he was alleged to have committed my crime before he went to prison, but they, didn't solve it, didn't charge him until quite a bit later on. So he was in prison at the time, and then rather than send him over into the local jail, which I filed a motion for and was denied because security, they took him to Walla Walla, and they just transferred him there, and they kept him in the IMU, the Intensive Management Unit, which is not per se solitary, but it's like maximum. And so the solitary unit in the IMU, administrative segregation is what they call it in Washington, ADSEG, that would be roughly the equivalent of where Mr. Allen was. So I have a sense of this place because, just for example, That's where the Green River Killer was held until he got transferred over to Colorado. He was in a private prison in Colorado for a while. I'm pretty sure they had to send him back, but that's where he was. Okay, so that's who Mr. Allen, that's who he was housed with, that kind of person. So my client is over here in the IMU, and we have a murder case. We got to prepare for trial. There's a massive amount of discovery to go through, and some of this is digital. You know, it's video recordings. I can't just the explanation or the solution that you always get from the prosecutors or the prison folks. Well, just print it all out, bring it in paper. Well, I can't print out a video. That doesn't work. I can't print out an audio recording. We need to be able to listen to it. We need to be able to see it with our own eyes. And so arranging to try to get a laptop into the into the prison, you know, with a disc, so that we can look at this stuff. This is an undertaking. And so when you're already a public defender and you don't have a lot of time to work on any of your cases, when you have to spend hours dealing with prison administration, trying to figure out how to do an extremely basic part of your job that really shouldn't even be a question. How do I review my discovery with my client? I understand, although I don't like, you know, that people have to make decisions. They have to set priorities. You know, how much time can you spend on this bureaucratic nonsense, this nightmare? And what's the payoff versus can we just not do that so that we have all that time left over to focus on something else? Some clients are going to be okay with that. Some clients are not going to be okay with that. But it's just so unnecessary. It's one of these little systemic tricks that's out there to impair the right to counsel, impair the ability to present a defense. It's just these types of roadblocks that get thrown up. So this has been, you know, a lot of war stories on this particular topic, because it is more common than you might think. It's not unheard of, not unheard of. Obviously, my last situation is different because he had been convicted of something, and he's in prison. But the gentleman from Clarkston, no, it's pretrial detention. Took him over to Walla Walla, 150 miles away from his lawyer. You know, want to talk about a roadblock? Now you got to do a 3-hour, you know, 2.5-hour one-way drive plus deal with the administration to be able to get your computer in to review discovery. Yeah, no. Didn't win that issue on appeal, but, you know, of course, I didn't necessarily expect to. It was an underdog position. But, yeah. It should be a violation of the Fifth Amendment. It should be a violation of something, certainly, in my opinion. But, no, courts are going to say, it's not punishment, so it doesn't count. It's for his own good. It's for his security. And you saw that in these proceedings as they played out in court. You know, to see this order with these findings, he's actually treated better than other people in that prison. Well, he damn well should be, because he's innocent. He's not a convicted felon. He doesn't belong in the solitary unit, which is a punitive unit. He doesn't belong in there. That was something, I'll mention that too, just real briefly. That was a big deal during COVID. Isolation was a big deal during COVID because people, you know, prisons were using that justification. We have to put people in isolation for their safety, for health reasons. So somebody is vulnerable. You might have somebody who, you know, I don't know, had a organ transplant or something. You know, they're vulnerable. They take immunosuppressants, or they have suppressed immune system. Being out in general population when there's COVID outbreaks, which there were significant COVID outbreaks in the prisons in Washington. several deaths, lots of deaths due to COVID. Yeah, the solution, well, we'll just put that person in isolation. That triggered a lot of litigation challenge. Pretty sure even the ACLU got in on some of that in my state, because this is a punitive setting, and it is not appropriate to try to use that, for security justifications or health justifications or something like that. It's not healthy. It's not healthy being in isolation. So, not a good situation, but that's going to be the rationale, and the courts are almost certainly going to accept that. So, guys, that is all of the comments, and I think I pretty much covered everything that happened today. The only other thing I can think of that we had a moment. There were two things actually, and these were with the bailiffs. So I noticed today people were starting to bring water and snacks into the courtroom. And I was like, huh, interesting. Like, I guess, guess it was okay to get those past security or something like that. It's kind of out in the open. Nobody was really hiding it. It was a little bit irritating, honestly, because we do have these big, just major acoustic issues in this courtroom. You can't hear anything. They badly need to dampen the sound, because it just carries everywhere. It echoes, and then every little shuffling all over that entire courtroom picks up and gets amplified through the entire room. So all these little crinkling bags, crunching chips, you can't hear anything. Stop eating your chips in the courtroom. Well, at one point, the bailiff came over and took somebody had a water bottle, and the bailiff came over and confiscated it, took it away. And so that caught people's attention. They started hiding their little things back in their bag. But then we got a lecture. We got a lecture from Judge Gohl at the end of the day. I want to, again, remember as close as I can to verbatim what she said, because there was a, snippiness to it. But she said, I've observed people eating and drinking in the courtroom. There is a courtroom decorum order. No drinks are allowed. No food is allowed. Read the order. That was that. So folks got chastised for trying to stay hydrated in court and for crinkling on their chips, which I didn't necessarily have, such a problem with. Like, go do that in the hall, go eat your snack in the hall at least. But water, water, basic human need, hydration is extremely important. No, we're not allowed to have it. We have to go in and chug what we can in little 2-ounce paper cone quantities from the one drinking fountain that they have in the building downstairs on the first floor. Whenever she graces us with a 10-minute break to be able to get down there. So I learned from yesterday. Today, whenever we got a chance to get out of the courtroom, I was at that drinking fountain throwing back those stupid little paper cones of water. Yeah, can't bring in any water in the courtroom. Reasoning for it? You tell me. You tell me. Security, I'm sure. Sure, there's a security reason in there somewhere. So that was the first little lecture, little incident we had. The second one, right as the court had concluded, and people were getting ready to go, a gentleman came over in uniform. He announces himself as the chief of security or head security or something like that, in charge of security. And he said, I want to warn you not to have any interaction with any of the prospective jurors of any kind, or you're going to have to go explain it to her. So I don't know if something happened. I don't know if that's part of the explanation for why we seemed to get to 17 people today, instead of 16. I don't know. Uh, but it did seem like there must have been something that triggered that warning, because they didn't give it to us yesterday. Gave it to us pretty much at the end of the day today. Seems like maybe something happened, but we don't get any of those details. But I did find it intriguing. What's the threat? Having to talk to Judge Gohl. What's the threat? They know. Guys, they know. They know she hates us and doesn't want us there. And they know we know that she hates us and doesn't want us there. So they're using that as a threat. It's kind of wild. That's what happened today, guys. Pretty much the long and short of it. The Iceman 101418, I just don't understand how there hasn't been a SCOTUS case ruling whether someone can be held in the worst conditions without a trial. Yeah, I can maybe do a little digging on this issue and see kind of where it's gone and how it's come up. SCOTUS takes up very few issues. Very, very few issues. The vast majority of things that get decided, go to the courts of appeal, and the courts of appeal split. Not infrequently. They have different outcomes, different standards, different rationales, all of that type of thing. SCOTUS takes up issues that SCOTUS wants to take up. And so if they don't want to deal with pretrial incarceration, they're not going to deal with pretrial incarceration. They don't have to. Nobody can make them. It's entirely up to them what sort of legal policy they want to set. So I will take a little bit of look in that and see if maybe there's been some circuits that have given a little bit of guidance on how that works or why. But I mean, my expectation would be that it's just the same rationale for pretrial incarceration generally. They're not going to have a different standard for where you're kept, for being kept in jail versus being kept in prison. The justification is going to be the same as it is, if you're held without bail in jail pending a trial. And it's just, well, because you're a flight risk, or there's a risk that you would tamper with witnesses, or there's a risk that you would, commit a new serious crime or something like that. Conditions. One of the things that I think is potentially interesting in this context is because there is a fair amount of, a body of law dealing with prison conditions. A little bit, small amount from the Eighth Amendment side, the cruel and unusual punishment side. Not a whole lot, because it doesn't tend to go very far. It's a very strict standard. But there's quite a bit in terms of right of access to the courts, right of access to counsel. I bring this up just because, in Mr. Allen's situation, that seems to be implicated. His at least according to his attorneys, which I realize Judge Gohl has said none of that happened, but according to his attorneys, they were having difficulty being able to meet with him, prepare his defense. It was an access problem. And there is a fair amount of case law on that in the civil context. Prisoners often have a lot of time and a lot of incentive to become legally educated. I'm kind of out here on the radical fringe that this is a little bit of an aside, but I personally I believe, I'm a big fan of alternative pathways to legal practice, right? Not just go to law school, pass the bar exam. I'm in favor of broadening that. I don't generally like the guild in the first place. So the issue is that people in prison have a lot of time, have a lot of incentive to become highly educated, to like learn about their own process, but also, often end up helping other inmates do stuff. And there are some inmates who are extraordinarily skilled at legal research and writing. They are doing a better job than some of the licensed attorneys that do the work. But they do it all behind the scenes. They do it all without any kind of acknowledgement because they can't. They're not lawyers. They can't put their name on it. They type it up, and the name of whoever they're typing it up for, that's the name on it. That person signs it. I am of the radical position. I would like to see a pathway to legal practice, to straight up legitimate licensing for some of these prison lawyers. They are carrying the overwhelming burden of post-conviction work in the state because in Washington, in many places, you don't have the right to an attorney to help you file a petition for post-conviction relief. This is the mechanism that you need to use if, for example, you need to raise something that isn't already in the court record. So your appeal is where we have the transcript, we have the rulings, we have the motions, we know what arguments were made. We're going back to look and see if there were errors with that. But you can on appeal raise things like, my attorney didn't interview my alibi witness, and my alibi witness would have exonerated me, and they never followed that up. That's not in the record because the attorney never did it, so you don't get to raise it on appeal. Your avenue to do that is through post-conviction. And so habeas corpus is the federal post-conviction mechanism, and so many states have a similar post-conviction process, habeas-like process. So yeah, you need to present new evidence, you need to show your factual innocence, things like that. This is the way to do it. You don't have a right to a lawyer to help you do that. So folks in prison are bearing the overwhelming majority of the burden of raising these types of issues, helping people in these types of situations. Ineffective assistance claims almost always have to be brought up in that type of context. A lot of actual innocence claims get brought up in that type of context. And they get no acknowledgement for it, no recognition. And yeah, okay, you might get some moral rehabilitation out of it, but how about some practical? How about some practical rehabilitation? Because a lot of these guys, they're going to get out of prison someday, Anyway, I'm radical like that. I think that should be an option, but it's not right now. Anyway, because of that, a lot of these guys, they spend a lot of time filing 1983 claims. Section 1983 is the deprivation of civil rights, the civil lawsuit that you can file against the government. And so there is a large body of 1983 case law dealing with prison conditions, dealing with access to counsel and stuff like that. So this is a long explanation / answer to how there potentially may be grounds for civil recourse here. Civil recourse. A lot of barriers to 1983, but the possibility is there for Mr. Allen. So I do hope that is something that is at least, cross somebody's mind, maybe on the table. Obviously not the priority right now, but at some point, maybe they'll consider that. Tim Harris, Scott Sharp, true crime loser on YouTube, argued effectively, I thought, that the composite sketches are both supportive of match to Allen. A young / old look when side by side, surprised DA not going there. I don't know. I mean, I do think it's a little bit of a hard sell when the composites look so different. The sketches look so different. The hair texture is completely different. The first guy's got very short hair. The second guy has that curly hair, like Pelocino hair. The first guy has facial hair. The second guy has no facial hair. First guy looks 40s. Second guy looks 20s. It's hard to reconcile these as the same people. And so the solution that this is suggesting is that, well, both of them are actually bad. It's just if you put them together, you get something that kind of looks like Mr. Allen. But uh, that's working backwards. That's outcome derived. Because essentially what you're saying then is that both of these witnesses independently inaccurately described what they saw. If they saw Mr. Allen, if that's the theory, they saw Mr. Allen, then they both got it wrong. And I just don't know that that's really the strongest direction for the state to go. I mean, I've seen this this overlay. They did like an overlay and then compare it to Mr. Allen. Yeah, it looks kind of like him, but that's cherry picking. That's reverse engineering. That's taking what you have and making it fit. It's not generating the evidence from the witness and following where that leads. So I think that would be challengeable by the defense. I think they would potentially be able to even have some fun with it, make fun of it, mock it. You don't want your argument mocked. It's not a good place to be. So I'm not super shocked the DA isn't going there, because it would effectively require the DA to undermine their own eyewitnesses and say, well, actually they were both wrong, but directionally, right. It's just too challengeable, I think. So, well, guys, it's been a little over 2 hours. I am a little bit sleep deprived today. I was up a little bit later last night than I intended, so I am going to go ahead and check out, but I do get to sleep in. Tomorrow. Play a little bit of catch up. Get back on my A game, but get back sharp for these motions on Thursday. So I'm going to go ahead and head out now. I do want to thank all of you so much for joining me. Just really do appreciate all of the groundswell of support. Oh, I see. Let me pause. Time. Jeff is in the chat reminding me we need a notepad count. So guys, right now, I am averaging, well, today I was more about half of a notebook, half of a yellow pad. Yesterday I was closer to about 3/4 of a legal pad. I think I probably tried to scribble a lot more yesterday than I did today, because so much was repetitive. They were following the same patterns of questioning, the same themes. There really wasn't a lot of variation, so I didn't need to note a lot of that same stuff. I just mainly tracked what the responses were, what the jurors were saying. So I'm only at, a little over, approaching about a notebook and a legal pad and a half. What I have gone through is pens. I have gone through lots of pens. I'm on pen number 5. My pens have continued to run dry in court. So I almost ran out yesterday. I was kind of nervous. I'm watching it get fainter and fainter and fainter, but it did last through the end of the day. Whew, because I only brought 2. I thought 2 would be plenty. No, so today I brought 3. I ran out 2 of them. I was on that third. So yeah, I've gone through quite a few pens so far. But the legal pads are holding solid. I'm expecting that I'll probably average about a legal pad a day when we get into the evidence. I mean, it will depend, but because all of that's going to be unique, every witness is going to be unique, the information is going to be unique, there's not a good way to refer back or shorthand that. There's going to be a lot of details, and being who I am, I'm going to want to capture as many of them as I can and bring them back here to share with all you guys. So that's the notepad count. with that, guys, thank you again. Like I was saying, I really do appreciate the support so much, and obviously the financial support means a lot to me. The super chats, folks have been donating through PayPal. A number of people subscribed to my Substack. I also really appreciate, but I also want to give a shout out. You may have seen I got 2 new wrenches over here in my chat. I got Nicole Maxwell has a wrench, longtime OG member of the chat, OG mod. Really, really grateful to have her help. And then also Forensic Führer, another OG chatter, been around. I think she's a day oneer. I'm pretty sure Kay's been here since day one. So for them to step up and help out with, you know, like I've said, we're not heavy modders. We're a free speech zone here, but, you know, things come up. Nobody wants a bunch of spam and, you know, inappropriate suggestions and things like that. So there's stuff to monitor. And I really appreciate them being able to do that, because I'm just not very good, unfortunately, at being able to monitor the chat and think and talk at the same time. It's just a little too much for me. So I regret that I have to miss out on it, but when I do get to look over and see what's going on, I've always really enjoyed it. So that support is all really important to me as well, and I just really appreciate all of you. It means a lot. This is why I'm doing it. The fact that it matters to you guys. You guys care about this information, and it does matter. This is a case that matters a lot. Transparency in government, period, matters a lot. You know what we're really doing here? This is political speech. Okay, this is core First Amendment activity stuff, talking about the courts, even criticizing the courts and the process, and looking at it with an eye to, is it working? Can we improve it? How should we improve it? All of that type of thing. This is why we have that First Amendment, guys. This is core political speech. So I find it much more meaningful than the type of political speech that revolves around, you know, whose ballot we're casting in November. But, you know, that's just me. So thank you all for joining me in this undertaking. Thanks for your attentiveness, your questions. Real quickly, I see we have a new member here. Let's see. Yes, Annie Land. Annie Land is a new member. Welcome, all the new members. Thank you as well. Thank you so much. I really appreciate you guys. So we're getting underway. You know, we'll get some substantive stuff on Thursday, some rulings, some decisions on these motions in limine, and then Friday we'll start to get into the real meat of the case. I'm really looking forward to the full openings. I'm so crossing my fingers that I'm going to be able to get in. Do have plans to be there, you know, bright and early, ready to wait. So until then, guys, I'm going to enjoy my day off tomorrow, work on getting caught up on some of this basic stuff so I can get back to you on Thursday and look at that composite motion, see where we're at with that. And in the meantime, I hope you guys all have a wonderful evening, and I look forward to seeing you next time. Take care, everyone.